Hi, you should get your names down, I guess, so if you wouldn't mind us getting your full name.
Analise Ritchie.
And Analise.
Analise.
Yep.
And then Ritchie.
Thanks, Analise.
Brooke Evans, Brooke with an E.
Fantastic, and you're team 119.
Yep.
Before we do begin, I'd like to welcome everyone to the Client Interview Grand Final. I know we've had 28 teams and now we're down to the final 2, so it's a big cut-off. I'd like to congratulate all competitors because the score sheets that I've been looking at have been marked extremely high. Just to introduce the judging panel today, we have Helen the Big S from ANUGLP. In the middle we have Catherine O'Keefe, who's a Senior Associate at Cause Chambers Westcott, that's right. She's also a Trobe alumni, and on our immediate right we have Craig Collins from ANUGLP. When you guys are ready, we can start, and yeah, we're good to go. I wish you both best of luck.
So those same as the last time I saw you.
Yeah.
If you want the extra 5, just weave it into your conversation.
Yeah, absolutely.
And the time will start once you go and greet your client.
And we've got our timing visual over here.
And you have so you will have a
Countdown.
You will have a countdown.
So if you're wondering what's going on over
sorry.
there, that's a significance.
Thank you.
Yes, I'm not super odd.
Hi, I'm Analise Ritchie.
Steph.
Nice to meet you, Steph.
Brooke, lovely to meet you. Please just take a seat. Thank you.
Not too much trouble finding the office or anything?
No, not at all actually.
That's good, thank you.
Area.
Oh, excellent. So I'm sure you're aware we have you booked in for a half-hour consultation today. In terms of how we usually run a consultation like this, we do have just a couple of housekeeping matters that we just quickly will get out of the way.
Sure.
Then we'll give you an opportunity to tell us about why you've come to see us. I'm sure we'll probably have a few questions just to gather a bit more understanding of your situation and things like that. And then more towards the end, we can offer you some preliminary advice. I would stress that this is obviously going to be subject to collecting more information and doing further research and things like that. But we can just give you an idea of like where to go from here and things that we can help you with, things that you can do and things like that.
Sure.
Absolutely. If at any point you don't understand anything or we're moving too fast, don't hesitate to stop us, ask what that means. We can slow down, clarify things like that. In terms of housekeeping, the first matter that we do have to get out of the way is just our retainer. So, as I said, this initial consultation is free. However, if you do decide to retain us and use our services further, it is at a rate of $150 an hour. I'll give you this document here that just details our retainer and things like that. Also down the bottom is just our contact details and the contact details of the firm. So if any time you need to get into contact with us, don't hesitate to do so.
Sure.
Have you been to see a lawyer at all in relation to this matter?
Yes, I have.
Okay,
Yeah.
so you have seen a lawyer?
Yes, I have. Yeah.
Okay, well you may or may not be aware from your time with that lawyer that anything you say here, any notes we take and so on, is confidential. There may be a few instances where we would have to break confidentiality, but if we are approaching that area, we'll stop you, warn you, and you can make the choice whether you want to continue on or not.
Yeah, sure.
The final housekeeping matter is just that if any conflict of interest does arise, we may not be able to act for you, and we'll have to refer you on to somebody else who is able to help. A preliminary check doesn't seem to give rise to any issues, but if you notice anything or we notice anything, we'll stop and take appropriate action then.
Sure.
So with all that out of the way, tell us a bit about what brings you here.
So you should probably already know who I am. I'm quite a highly sophisticated client. I'm CEO of Lloyd Group. Have you heard of us, done a little bit of research into us at all?
Yeah, we are aware of your group.
Sure. So yeah, we our major product are pharmaceuticals, leaders in the field.
Yep.
We are of course an ASX listed company as well, so very popular, very high sales. I really pride myself on that. Look, last week the ACCC and the AFP stormed our offices in a dawn raid. We have 3 offices, as I said, quite a large company. It was terrifying. I actually haven't slept. So I'm very stressed about this.
Absolutely.
Yeah, so The raid actually came with a section 155 notice to produce documents. It was relating to an understanding or an agreement to control pricing with one of our competitors. Of course, no one sells products quite like us. So as we are the leaders in the field, the competitor XYZ is quite a small competitor.
Okay.
So ultimately, I believe this actually indicates, well, that the AFP and the ACCC have some sort of suspicion over cartel conduct, but I don't want to go to jail. I don't want to go to jail. So I've worked far too hard and my reputation is far too important for this.
And it must be very stressful. We'll do everything we can to help avoid that.
Yeah, I mean, this never happens in Australia. It's pretty much unheard of. So the fact that it's happened to me, it's terrifying, very embarrassing.
Absolutely,
Yeah.
we can very much empathise
Yeah.
with that situation that you're in. Can I take you back? You said that you had an understanding or an agreement with one of your competitors, XYZ.
Sorry, I didn't actually say that I had an
Oh,
agreement.
this is
I said
an
that
alleged
that's what they
agreement.
said.
Sorry, I
Yeah,
apologise. Yeah, absolutely. Do you have any idea what that was relating to?
Well, they haven't really given me much information. You know, they did these dawn raids over our 3 offices over this suspicion of cartel conduct, over they suspected that we had this agreement.
Yeah.
So, yeah.
Do you have any business relationship with XYZ?
So, we, at my company, there was a board meeting about 6 months ago, and as a draft proposal, we have this thing called Project Casper. So the proposal was based on a customer report by a sales team to improve the uptake of our product in regional areas.
Right.
So I suspect that's what they caught wind of, and they now suspect it's cartel conduct.
Okay, and as part of Project Casper, was there an intention to work with XYZ in some capacity?
Well, of course, I only attended the board meeting.
Right.
I didn't attend any further meetings. I believe that one of our general managers had reasoned that based on our current customer data, the business could increase a regional market share by increasing the uptake of our product, of course, by among the regional users. So ultimately, the rationale was that in order to increase our slice of the pie, we must increase the size of the overall pie. So I guess the pharmaceutical industry.
Okay.
Well, to do this, ultimately our business would need to keep prices low.
Yeah.
That's just how it is.
Yeah.
But so would our competitors. So I guess XYZ Group. So yeah, we did discuss a little bit about that.
Right.
And that was in the proposal. Again, I only attended the board meeting. I believe the proposal was given the go-ahead. So yeah, and I think that a couple more things came out of it.
Okay. And so are you aware, just to confirm, XYZ was involved in these discussions and talks around both maintaining prices at a low level? Were they associated with those conversations at all, agreed?
Well, they weren't obviously a part of the board meeting, and I didn't have anything to do with it from then on in. I really don't think I should be, subject to this, but I know the general manager and some other members, they did form this Project Casper. It did continue from there. I heard about an industry meeting, and they presented their idea, and following that, I believe a Skype group formed.
Okay.
And ultimately the members in this Skype group chat formed, they discussed pricing, and I think a price figure was agreed on, and XYZ was a part of that Skype group chat.
Okay. And were you aware of anyone else other than members of your business and the business of XYZ that were a part of that group chat?
Do you think I've colluded with someone else?
No, absolutely
Whether
not.
you have any suspicion that there might have been anybody involved. We're just trying to cover all bases. We're not accusing you of anything wrong. We're just trying to gather as much information as we can so we can help you take the right steps from here.
Just, yeah, in terms of helping you, it's best for us to just know absolutely everything about this situation so we can give you the most accurate advice. Yeah,
Okay.
we wouldn't accuse you of anything, absolutely.
Okay. So I believe that XYZ group,
Mm-hmm.
they invited a third competitor
Right?
to the Skype group chat. I don't know who that competitor is, sorry.
Okay.
So I believe we do have the details of the third member,
Okay.
and I am now coming to see you because
Yeah.
I don't want to go to jail,
Absolutely.
and I would like some instructions whether to disclose
Yes.
the existence of this third member of the cartel, or the alleged cartel.
Yeah.
So, yeah, I know that you can't provide me an answer today, but that is ultimately what I need to get at.
Yeah.
I understand.
But you don't, in terms of today, you don't have any information as to who this third party is?
No,
Absolutely.
I have the details somewhere.
Yeah,
Don't
absolutely.
have it on top of my head.
Documents, yeah.
Fighting
no
for
problem.
them, I'm too busy.
Yeah, I can understand that.
Yeah.
In terms of these discussions between the three bodies, are you aware of anything beyond the discussions of price that have been agreed? I know you talked about wanting to move into the regional markets. Was there any discussion of kind of where each body would operate or primarily focus on or anything like that?
I wasn't part of the Skype group chat.
Yes, but are you aware of any discussions in that regard or anything beyond the price matching?
As I said, a price figure was agreed on for
Yeah.
each quarter. That's it.
That's
yeah.
it, okay.
So you would say the primary goal of this group chat, in order for all of you to be able to increase your profits as a group, you've agreed to maintain a minimum price in order to perhaps not compete with each other so much.
I didn't agree on anything.
Yes, I apologise.
The
Yeah,
rest of
as
the
part of that
members
group.
did, yeah, the
Yeah.
general manager. So yeah, their pricing information was shared. An agreed price figure was provided for each quarter. I did not know about Project Casper. I was only a part of
absolutely.
the original board meeting where the proposal was presented.
Okay.
So did you only come to know about Project Casper when you received the notice from the ACCC?
So the dawn raids, yes,
Yes,
yeah. So
And I noted you said you did receive a notice to produce. What exactly did it state or request from you?
I don't have the exact details. It was just to produce documents relating to the agreement with XYZ Group to control pricing.
Absolutely.
Yeah.
And could I just confirm, is there any relation beyond these discussions between your company, XYZ, and the other third party? Has there been any previous relations between them, any other associations of any kind?
Any joint projects, anything like that?
We've never had to. I've got a very established company.
Yeah,
I've
absolutely.
never run into any trouble at all. So
Yeah.
no, not at all.
No.
And there's no kind of common companies or anything between the three bodies. They're all completely separate competitors.
Yes, they're all
Okay.
completely as in I'm the leader, my
Yep.
company's the leader, and then everyone else is a little bit lower.
And these are all three in the pharmaceutical business?
Correct.
Okay.
Have you spoken to the ACCC or the AFP since the raid and the notice, or had any other discussions with them?
No, not since. As I said, I did previously go to see a law firm.
Yep.
And, you know, it was just in the panic at 9 a.m. in the morning. My general counsel had instructed the firm.
Yeah.
So those are the only other people I've spoken to about it.
Not a
Yeah.
problem. And can I ask, in terms of seeing the other lawyer, when was that?
That was 9 a.m. in the morning on the same day
On
of
the
the
same
raid.
day.
Yeah.
Absolutely.
Look, that dawn raid was handled terribly.
Okay.
And this law firm, Forrest Chattel Solicitors, they were just awful. They handled it terribly.
Okay.
And to be honest, I'm very much a fan of going digital with firms. They use a lot of paper. Do you think that's terrible? Would you agree that's just awful?
Yeah, I have to agree. There's a lot of environmental concerns, but just in terms of we do have a limited time here today, and we want to give you the best possible information that we can, and make sure that you don't have another issue with the law firm. So we'll
Okay.
try to stick to this. Can I ask a bit more? So you saw this Forrest Chattel and Co. directly in relation to this matter?
Yes, I called them. in the
Yeah,
morning.
and you visited them? Yeah, and did they provide you with any advice or anything like that?
Not particularly. That's why I found them incredibly useless. And of course, I have used your firm before, so
Yes.
I assume you guys will take great care of me.
We'll do our best to provide the best assistance possible. Did anything else come of your discussions with the other firm, or it just kind of ended after that initial consultation? There was no other correspondence or action taken?
Nothing has happened since I've come to you since. Yeah.
And are you aware of any action either by the ACCC or the Federal Police in relation to the other groups that were part of this agreement?
No, they conducted these dawn raids. They took a whole bunch of documents.
Okay. Are you aware of what these documents related to?
Well, they took a hard drive,
Okay.
and I saw on the sealed envelope it was marked, subject to privilege claims.
Yeah.
So yeah, I believe they're privileged as from running terms of our documents, things with, terms for litigation and legal, and they just took the whole drive and they marked it subject to privilege claims. They took a copy, of course.
Yeah.
But they agreed it wouldn't be opened until we would now have a chance to look over the documents. General counsel from, my business looked over the documents and said that all of the documents are privileged, so I don't think it's much to worry about. There's about 13,000 documents.
Okay.
Has anything like this ever happened before with your business? Is this the first instance in this regard? You've never had come into contact with the ACCC before?
No, do you think that my business would do anything like this?
No, it's not that we think that, again, this is just the kind of information we need, as it will affect what steps you take and what possibilities there are for you.
Sure, no, we've never engaged in anything like this again. I had no idea about Project Casper, and it really is absolutely terrifying. I'm pretty terrified. I don't want to go to jail.
Yeah, absolutely. So just confirm, there's been no interactions at all with the ACCC in the past?
No.
And since the raid, have you received any, obviously you got notice about the raid and things, have you had any other letters, communication, anything from the ACCC?
No, not at all.
No, not at all. Okay. Alright. So what we'll do now is I'm just going to quickly sum up what you've told us today and what we understand your primary issues are to be. And then based from there, we can give you a bit of an explanation of what exactly is involved in cartel conduct, the consequences, and what we can do from there. Does that work for you? Is there anything else you would like to tell us before? Any questions or anything?
No.
Okay. So our understanding is that you are the CEO of Lloyd Group, a pharmaceutical company that's had great success. Last week, the ACCC, in conjunction with the Australian Federal Police, conducted a raid on your premises, 3 offices. Yeah. And in terms of this raid, their intention was to investigate what they allege is cartel conduct between you, a group called XYZ, and another third undisclosed group. Right. And in terms of the agreement that they are concerned about, it's between you, XYZ, and this other group, which you guys did intending to increase your profits, and part of that was to agree to have a uniform pricing of your products in what you thought would drive up profits, particularly in regional areas and things like that. Absolutely. Just in part of the raid, there was the collection of a hard drive which had 13,000 documents and was marked privilege. In terms of why you've come to see us today, we can see that you're obviously very concerned about the criminal consequences this will have on you. Absolutely. And a big thing is avoiding jail.
Yeah.
And it's something that you don't believe is appropriate for you given your lack of involvement perhaps in this project.
Yes, correct.
Yeah.
Yes.
Absolutely. So in terms of cartel conduct, I'm sure that's probably something that's particularly confusing to you. Is that something you'd like me to explain a bit further?
I wouldn't say it's confusing, obviously.
Yeah,
with
no,
my
sorry.
status as CEO, I do have some knowledge of it, but
Absolutely.
sure, if you would like to explain.
Yeah, it is something that's particularly complex, and I know even in my experience with the law, I haven't had a lot of experience with it, so it's something I've had to research myself, even
Yeah, sure.
as someone as part of the law. So essentially what the consumer law encourages is fair competition between businesses who are in competition with one another. So for example, you, XYZ and that other third company. As part of this, they prevent what they call cartel conduct. Now what this is where businesses who are meant to be in competition with each other make an agreement. This can be an informal agreement, so just even an understanding, or it can be a contract to engage in a range of conduct. So one type of conduct that they do prohibit is price fixing. So that's where businesses who are meant to compete with all agree with one another, all agree on a set price. So essentially you're giving the illusion of competition, however, that may not actually be a thing. In terms of that, if it is found that a corporation or an individual has engaged in such behaviour, there are both civil penalties in that you may receive or your corporation may receive a fine, and there's also criminal penalties which do involve a prison term or additional fines. However, there is a number of options and there's exceptions to this rule, and there's a concept of immunity, which Brooke will go into in a moment, which mean that perhaps you won't face these civil and criminal penalties.
Excellent.
So Brooke has a pretty good explanation of these for you.
So as Analise was saying, there are a number of exceptions that hopefully you might be able to fall under. If not, there is the immunity path as well.
Some of these exceptions include whether you have actually sought authority from the ACCC and whether you've notified them. Given you said you had no interaction, my understanding would be that that's not going to apply to you.
Sure.
The other avenue is that we argue this was simply a joint venture, that you remained as your separate entities and combined into one joint enterprise, essentially in this particular regard. That again, there might be some difficulty. It is obviously a fine line between a joint venture and going into that cartel territory.
As my colleague said, there may be the opportunity for you or the company itself to apply for an immunity. What this means is that you or the company, depending on whose behalf the immunity is applied for, will not be liable primarily to civil penalties, as this will go through the ACCC first. So I'll cover the civil path first and then we'll get into the criminal element. So when applying to the ACCC for immunity from any action with regard to the cartel conduct, you must have been a party to the cartel. So given you are the CEO, you may fall into that party, but it may require some acknowledgement of what was going on, essentially. I know you said you had no idea, but you know now, I guess would be the case. From there, you have to admit that the conduct that you have become aware of may be a breach of the consumer law. You acknowledge that while you don't feel you've done anything wrong, it's still an alleged breach. You understand that if this conduct is seen to be cartel conduct that your general manager and other colleagues have engaged in, it would breach the consumer law. Does that kind of make sense?
Yes.
Yes? Okay. From there, you have to be the first party to apply for immunity. So this is a kind of act relatively quickly situation.
Okay.
So it is essentially first in best dressed, if you will, applying for immunity. So it is in your best interest to act quickly if you want to follow this path.
Sure.
From there, if you are seeking immunity on behalf of the company, you have to acknowledge that this is the company at fault. It has to truly be the company acknowledging their fault, given you're the CEO. Again, that's just specific to if the company itself is seeking immunity. From there, you just have to ensure that you're providing full, frank and honest disclosure. So anything you know, any information you think might be able to help them in their investigation, you forward on. You help them in any way you can and you continue to cooperate as long as they need your assistance, essentially.
Sure.
And from there, if the ACCC believes that you do meet the criteria for their immunity, they may refer it on to the Department of Public Prosecutions, who would deal with the criminal side of things. So I know your concern is primarily avoiding jail.
Yeah, absolutely. Yeah.
So from there, the DPP will make their own decision as to immunity, and if they believe that you did meet the ACCC criteria and you agree to cooperate with them, provide them any information you can, be honest with them, full and frank disclosure, tell them everything you know, agree to act as a witness for the prosecution if it comes to court proceedings, they again
may be able to offer you immunity from any criminal penalties. So essentially avoid that jail time or any further criminal fines, which I believe is your primary goal today.
Absolutely, yeah. I'll just add an important requirement of this, and something that we would suggest as a first step if it is found that the agreement that has been made is cartel conduct, would to be cease that agreement. And that will be particularly important in terms of like gaining immunity and things like that. It does appear preliminarily that this is perhaps something that would be prohibited by the consumer law. However, we would have to see whether there was an agreement reached and things like that, and if it was specifically to price fix and things like that as well.
Sure.
Yeah.
And just on that note of immunity as well, I did mention before that you could apply for immunity on behalf of the corporation itself or for yourself. So I will just quickly note that there is what they call derivative immunity. So where one person applies, others may seek kind of immunity that flows from that. So whether that be that you apply on behalf of the company and seek derivative immunity for yourself is an option that you should be aware of, just to cover all bases.
Yeah.
Did you have any questions around kind of the action the ACCC may take and the penalties my colleague spoke about, or your options in terms of immunity?
No, that all seems quite clear. So what will you help me with in relation to all of that?
Well, we can help you. Like, we will absolutely help and guide you with this whole process. However, it is a lot of the interactions will be with the ACCC, and in terms of, it's going to be the most appropriate avenue for you, particularly given it doesn't seem that this is something that you're aware of. I mean, something that is really important is if you were aware of it in any other form, that you tell us that. Is there anything that you can think of aside from the board meeting that you interacted with Project Casper?
Told you everything I know.
Absolutely.
On that note, I will just note that that is something that will be considered in terms of criminal penalty that you were concerned about. To get from that step of any civil to criminal liability, there had to be some knowledge or belief on your part about the actions that were going on.
Yeah, so in relation to you helping me with all of this ACCC stuff.
Yeah.
Look, as I said, my last firm was absolutely useless. So if you could, arrange all of your juniors to just work through the night tonight, we could try and get this sorted as much as possible. That really seems like something I need.
Well, we will absolutely do everything possible that we can to help you. In terms of the first step that we have to take is agreeing to cease this conduct. And then in terms of the next step that's most important is contacting the ACCC, And then if we go down that route, if you seek immunity, not only are you going to possibly avoid criminal and civil penalties that we outlined before, but you also avoid going down the lengthy and costly task of going to court and things like that.
Yeah, absolutely.
Which I'm sure is something you probably want to avoid.
Yes,
Yeah, and you approaching the ACCC if you do believe that you want to apply for immunity and so on, rather than just completely, kind of denying the claims, which is more where we would come in. We'll obviously avoid your paying our costs. So this is kind of a whole cost minimisation process, and acting in your best interests, approaching the ACCC and trying to come to some sort of solution in that regard will be the most efficient and hopefully effective course of action.
I will stress though that we are absolutely, I understand you're very concerned about this, and given your previous experience with lawyers, you're wanting someone who will be particularly helpful and guide you, and we will absolutely do that for you. We'll help you as much as we possibly can. And as I said before, you've got our contact details. If you have any concerns at any time, feel free to either contact the firm or contact us on our phone numbers and things like that.
So do you feel secure in what steps you need to take from here, and you can revert back to us for any further assistance in terms of dealing with the ACCC that you might require?
Yeah, absolutely.
You feel secure in what steps you need to take and understand the different penalties and that might apply if you don't act appropriately?
Yes, as I said, I really want to get most of this done this afternoon, so working through the night, if that's what it requires, and as much assistance as you can provide.
Yeah, just in terms of managing your expectations, I understand that you want this done as efficiently as possible. While we're going down the more efficient path, it's not going to be something that's done overnight.
Okay.
We will,
Sure.
Like, I understand it's something that you would want, but just in terms of being realistic about this, we will help you so it's the most efficient and easy process as possible. But yeah, just
It's better to cover all bases and take the necessary time.
Sure. Yeah.
are there any other concerns at all that you have today?
No, I feel as though that's pretty much covered
Is there
everything.
no questions or anything?
No.
Nothing else you can think of that might help us?
No.
Okay.
Absolutely.
So we will send you out an email, no
Excellent.
letters,
Yeah.
and confirming everything that we've spoken about here today and reiterating what the next steps are and what action you should take, what action we can assist you with. And if once receiving that email you have any further questions, please don't hesitate to come back and talk to us.
Okay.
We can
sure.
also provide you with some references. The ACCC actually has a lot of good information on this topic, so we can provide you with some references just if you want something to look to and gain a bit more understanding or anything like that.
Sure.
But as I said before, you've got our contact details. Don't hesitate to contact us at any time.
Sure. Excellent.
Yeah.
Thank you very much.
Great to meet you,
for your
Steph.
help.
No problem.
Thank you.
Have a good afternoon.
You too. So you've got your 15-minute debrief. Did you want to do your 5 minutes
Yeah,
outside without your huge audience?
that would be good.
And then come back once your 5 minutes are
Perfect.
Thank you. Thank you.
finished off.
Just let them read. Yeah.
So whenever you're ready to start your debrief.
I think overall we were relatively happy with how we did. There was a lot of different strengths and weaknesses that we kind of looked at. And
Yes.
some things we did not as well as usual, but some things we think we did well.
Yeah, I'd have to agree with that. We think that it was probably a pretty good performance, but we definitely both did identify some weaknesses in things that we did and things we did as a team and things like that. I think as like a preliminary matter that one of the things we think was a strength was just the working atmosphere we created in terms of like maintaining a professional relationship with the client. However, also acknowledging that she was like particularly stressed and perhaps even angry about this issue and almost hostile in the way she responded to some of our questions and things like that. So kind of acknowledging that and being empathetic to, obviously she's in a very stressful situation and obviously would be very upset about this. But then, yeah, walking the line of professional and empathetic.
I think in that regard, sometimes we managed the hostility well and were able to kind of rein it in, get her back on track, and there was other times that we probably could have done that better. And we were talking about sometimes just in the language we used, accidentally kind of saying you, and where we probably could have said Lloyd to kind of help her get that separation between, it was the company that did it, like other people in the company that did it, I've only just found out, are you accusing me of it? Like reiterating that it's the company that's kind of having the issue, not her.
I think also one mistake that I personally made in trying to calm her and relate to her and things like that was perhaps language I used in suggesting like it's okay that she doesn't know because it's a complex area of law and things like that, and perhaps my language in that aspect wasn't the best. I think we got a pretty good understanding of her goals and expectations. I think we both outside were like there's perhaps little things that we could have questioned her more on that or kind of gone down that path. But I think we got a good understanding that her primary reason to come to us today was obviously she was concerned about the investigation by the ACC and the AFP in relation to cartel conduct. And for her personally, a big concern was that she would face some criminal penalties. And yeah, just also like concerns ancillary to that, like continuing on with her business and resolving this in a timely manner and things.
I think with regard to resolving in a timely manner, there obviously was the issue if she wanted it done all overnight, and we probably could have said earlier that that's not realistic. You know, cartel conduct is a big thing. We have to tread carefully almost and not just rush it in one night and force the matter. And that's something we probably could have, when we said, you know, it's not realistically going to happen overnight, that's something we maybe could have said slightly earlier to kind of stop her
I think
in that sense.
I think it was good that we acknowledged, like, given she kept on saying, get the junior lawyers to work overnight and get it done, like, acknowledging that that's not something that's realistic, just so we can manage her expectations, and then she doesn't go away and when it's not resolved tomorrow, she's disappointed and angry and at our service.
I think in terms of the choices we gave her, maybe we didn't give her many, but we think that we gave her what, in this sense is the most appropriate choice, and we gave her that option of she can take immunity for herself and she can take immunity, she can try act, for the company and seek immunity for the company, given, she seems to really love her company and the work she does and would want to protect that. So there was that option of trying to surrender it as a company act and then seeking derivative immunity for herself, which I think was a good option that we presented to her.
Yeah, and then obviously just in terms of going down that path is going to be a less costly, less alternative than going to court and dealing with this matter like that. I think one thing that we thought we did do well was our teamwork. I think over the course of this conduct, we feel like, of this competition, we feel like we've kind of gotten into a good rhythm with each other and a good balance between our equal contributions to it, and
we kind of know what the other's good at to kind of know when, that's the part they should be speaking and this is the part I should be speaking.
Yeah, playing to our strengths and weaknesses, but then also we've kind of got a structure to ensure that we do touch on everything, make sure we do deal with the housekeeping matters which are important in an initial consultation like this, and then doing that efficiently to have time to hear her whole problem and ask her some questions and then give advice and ensure that she's understanding that and things.
I think the housekeeping is something particularly important in this regard, given she did say she's a high profile client, even just reiterating confidentiality is something that definitely needed to happen, and we got out of the way early, so she was reassured about that.
Yeah, I think that's our time, but I think that was pretty much everything that we touched on outside.
Did you have any thoughts?
We're still reflecting, or we're giving feedback?
We can give feedback now.
Sorry, is that the end?
Yep.
Oh, all right. Okay, well done. So you've made the grand final and you're clearly very polished, and I have to say some things that stood out to me are your listening capability and the tone and rhythm of your voice and questioning and so on. So well done, you've obviously developed these skills to a high level. I've got some splatter of comments that might be just used for feedback for the future as much as anything, and I won't labour them too long, and others might have other things to say. So I'll just quickly run through them. I usually think there's a great opportunity to make more or small talk. We come in, we shake hands, we say, any trouble getting here, bang, the formalities. Now, as it turned out, this was an anxious, sleep-deprived client. Now, sometimes the small talk, you can suss it out, just by a general fishing line going in there about the state of your client, right from the beginning. So keep that in mind as a possibility. Another thing, and it's triggered with experience by interviewing a person who is a director to be crystal clear who your client is. Is it the company or the director?
Yeah.
And we're here in a scenario where we've got, corporate responsibility, and the director person is just sort of, just take it to that next level of nailing that down. Who are we representing here? The company, the director, or both? Bang, so, are you feeling okay? Might have been slipped in there just to suss out the capacity of your client. Who are you talking to? Somebody who's really, so anxious and sleep deprived they can't give, Anyway, there might have been, I'm really big on reflecting back and questioning is one thing of getting information, but, and there was a brilliant recap towards the end, in my view, about, everything that had happened for 20 minutes or so. Amy summarised that quite succinctly, but I think there are opportunities along the way to reflect back, especially framing the problem at a fairly early stage. I understand from what you're saying, the big picture problem is a couple of sentences. Bang. So we're all on the same page about the problem that's on the table. rather than leaving that until you sort of trying to do it all together in a big package. Yeah, you're right. I think in your reflection, perhaps went a little bit too far in trying to be reassuring and sympathetic in saying we wouldn't accuse you, because you might end up having to write a letter of advice saying we think you're liable and there are jail penalties. Now, we're not accusing you, but where you have, you know, as a lawyer giving advice, that might be an end point. So you just be careful about your language in trying to be sympathetic and reassuring that you don't close off that possibility. And also, I guess, the key event here was the raid, and perhaps at an early stage you might have reached for the toolkit of when, who, where, how, why did the raid happen, you know, and just, because that's the event that's just happened, and that's significant, and you can learn a lot by drilling into the detail of that key event that's just happened, and perhaps at an early stage. All right, and in terms of options, you know, you managed that pretty well, but you know, we all need to be crystal clear about exactly who does what next, and the client gets up and leaves. Well, are we clear entirely what they're going to do when they sit down in the office? And there's a reference here to 13,000 documents that are contested potentially, and maybe that's a...
All 13,000 of which apparently are privileged.
Right, so that's a big job, and maybe that's a reason why things can't be done by tomorrow. But anyway, I'm going on too long. I should hand over to Catherine, but anyway, I hope that's useful.
Thank you.
I agree with everything that was just said. I think your self-reflection was really good. It shows that you're aware of performance, and sometimes it's really easy to get swept up with the client and then go, oh dear Lord, I can't believe that's just happened, and how do I get out of it? So I think you worked really well together. So for example, when you forgot the word alleged in relation to the agreement, that can happen really easily, but Brooke jumped in really nicely. So your teamwork was really evident, and I'm sure if we'd seen you several rounds ago, you know, there might have been speaking over each other and the rest of it. None of that was prevalent at all. I think understanding your client is a really big one, because you did raise conflicts of interest in your retainer. So obviously you weren't conflicted as a company or as a firm against Lloyd, but would you have been conflicted if you were acting for both? So just things to be aware of, and picking up on the 13,000 documents and privilege, it might have been a good opportunity to go through sort of what privilege is, because you've used confidentiality in your retainer but not necessarily covered the difference between confidentiality and privilege. So just little things like that that definitely come with time, and you know, don't necessarily come out in a competition, but just for future future reference. But all in all, you both did really well. You dealt well with a client who was clearly stressed at times, you know, could have really rubbed someone up the wrong way. So you've done really well today.
Thank you.
Thank you. I agree with both Craig and Catherine. One thing though that struck me is that she said, got general counsel, I've been to see another firm of solicitors. You're like the solicitor number 3 that she's seen in, potentially less than a week. To me, I'd be like going, what are you doing? Fishing for the right advice? But perhaps that would just, I know that she said she wasn't very happy with the outside counsel, but kind of wondering why general counsel in this instance might not have been dealing with the problem, and that's where their conflict may have arisen. Overall, I agree. As a team, you work really well together. You do have your rhythm down quite well, and your self-reflection is, as always, insightful.
Thank you.
Thank you.
Hello again. I feel like I'm the one undergoing a test, you know. You should know your name.
It's okay.
For the benefit of my fellow judges, would you like to introduce yourself?
Absolutely. I'm Eilish, Eilish, Buckley, Buckley.
And Jess.
Dellabarca, which is Dellabarca.
Excellent, thank you. And team number 1, she said.
Yes.
So, same rules as when we last met. If you need your extra 5 minutes, just read it into your conversation. You actually, today, you're very lucky, you have a dedicated timekeeper here to our left. Okay. She will be giving you a countdown, she's not doing a weird dance. Or maybe she's, I don't know.
You can ignore me as well. Exactly.
Your client is ready whenever you are.
Thank you. Should we make it interesting?
You can't do it.
Okay.
Sorry.
No, that's okay.
It's a permanent fixture.
Oh, can I just double check when the time starts?
Yeah, so once you welcome the client in, I'll press start.
Okay, I'll press start now.
Hi there.
Hi.
I'm Jess.
Staff lawyer.
Nice to meet you.
Hi Steph, I'm Eilish.
Nice to meet you.
Come on in. Did you find out if it's okay today?
Yeah, actually, I know the area quite well.
That's good.
So as we mentioned at the door, I'm Jess and this is Eilish. We're partners at Dellabarca in Buckley, but just call us Jess and Eilish. How would you like to be referred to today?
Just call me Staff.
Call you Steph?
Yeah.
Perfect. Okay, so just before we get started, we've got a couple of house meeting manners to get through. So the first one is confidentiality. So everything that you say in this meeting today is confidential up until a point. So there's certain circumstances that we're unable to keep the confidentiality. So that's things like a serious crime. How we'd like to proceed is if you're coming close to an area that we're unable to keep confidential, we'll flag it and raise the consequences of that. Does that make sense?
Yes.
Okay, perfect. So what we'll do is, if it's okay with you, take notes during this interview.
Yeah.
Right?
Yeah.
Great. So the next matter of housekeeping that we'll come to is the issue of conflict of interest. We may have to stop acting for you if we find out that there is a conflict of interest. For example, if anyone involved in your legal issue has obtained legal representation from our firm previously, we might have to stop acting. Do you happen to know if anyone has received legal representation in your issue?
No, I'm not aware of that.
Okay,
Sorry.
I'll make a note of that.
Perfect. So this initial interview is free. After it finishes, we'll send up some follow-up information about fees, but we'll do that after the interview. There's also some opportunities for legal aid or community law centres if that's something you're concerned about. But this, as we say, this first one is free. And we'll also give you our terms of engagement at the end of the interview. And this interview does not oblige you to take us on as lawyers.
Sure.
We'd also like you to encourage you to be as open with us as possible. We know that a lot of people come to see us regarding legal matters that can be stressful and complicated and personal. But even despite all of those things, the more that you tell us about what's going on with your issue, the better the quality of advice that Jess and I will be able to give you at the end of the session.
Does that all make sense so far?
Yes.
No questions? Okay. So what I'll do is I'll just give you a rundown of how the interview is going to progress. So what we'll do is we'll ask you some questions about what's going on, and then from there we'll ask some follow-up questions just to make sure we've understood what's going on. And then we'll be able to look at the problem from more of a legal perspective and be able to give you some options for taking this forward.
Sure.
Yeah.
So that's all the housekeeping out of the way. Why don't we start this interview by inviting you to tell us what's brought you in here today?
Sure, so I'm sure you already know who I am. I'm actually CEO of Lloyd Group. I don't know if you've done any research into us, I'm sure you have, but our major products are pharmaceuticals.
Mm-hmm.
So we are of course an ASX listed company, very popular, very high sales, leading in the industry.
Mm-hmm.
So actually about last week, the ACCC and the AFP, they stormed our offices in a dawn raid. We have about 3 offices, being leading in the industry. It was terrifying, and I haven't slept. Yeah, it really has been keeping me up.
Mm-hmm.
So the raid actually came with a Section 155 notice to produce documents relating to an understanding or agreement to control pricing with one of our competitors. But of course, no one sells products quite like us. So, we are the leaders in the field. The competitor, they're referring to XYZ Group. They're a very small competitor. They really don't match up to us or our quality. Mm-hmm. Now, I do believe this indicates that they have a suspicion of cartel conduct, but I don't want to go to jail. Not at all. I've worked far too hard. My reputation it cannot crumble. I don't want to go to jail. This never happens in Australia. It's completely unheard of, and it's now happening to me. It's terrifying. And it's a very embarrassing experience, with my reputation.
Okay, thank you for coming in here today. It sounds like it's been a really stressful week, and thanks for opening up to us. I think we'll just have a few questions to go on from that. When there was the dawn raid, what did the people who were coming into the offices, what did they say? Were they talking about criminal conduct or civil conduct?
Well, they just provided the Section 155 notice to produce the documents.
Okay.
They took some documents. They took some other things.
And you were cooperative with them?
Yes, of course.
Does that mean that you have then sent them documentation under that notice?
I haven't sent any documents.
You haven't
They took documents. They took a copy.
Okay, good copy. Hard copy or a soft copy?
They took, from memory, I believe they took a hard drive.
Okay.
Yeah.
Okay, so a hard drive. Do you have another copy of that hard drive that you would be able to pass on to us?
I do have another copy, but these very private documents. So yeah.
I think we'd like to re-emphasise at this point that this is a confidential appointment, so what you do have to say to us today would be confidential, and again we will let you know if it approaches something that we could not keep confidential.
Yeah, okay.
Yeah, but those documents would help us understand what ACCC have, the information that they have, just so we could provide the best defence possible at this stage.
Yeah, so the hard drive was quarantined, so I have the original copies.
Okay.
I believe they were also marked subject to privilege claims.
Should you be able to go into that a bit more, the subject to privilege claims?
Well, that was what the label said.
The label said?
So, I believe it was as a result of running terms used. I have seen a lawyer before, so the lawyer we saw originally, they didn't do much at all. Pretty useless actually. Look, the general counsel of my business looked over the documents and said that they were all privileged, so I don't believe it's much to worry about too much.
I think I might just ask a few more questions there, because privilege is quite a complicated area of the law.
Of course.
And so the privilege is between you and the lawyer, or is it what was the relationship that arose to privilege, to make those documents privileged?
Well, the documents, they were just tagged subject to privilege claims because of, as I said earlier, terms, search terms, so terms regarding, I think some of the terms were like litigation and legal advice, so anything with that in it was just tagged subject to privilege claims.
Right.
They said that I could go over it with my lawyer, so yeah.
Who said that, sorry?
Well, the ACCC.
The ACCC?
Yeah, when they took a copy.
Okay.
So they labelled it privileged.
Correct.
Okay.
I see.
Okay, that makes sense.
But they took those copies regardless of the privilege?
Correct.
Okay.
They said, I believe that it won't be opened until me and a lawyer had a chance to look through the documents.
Okay.
And determine whether there would be a privilege claim against
Oh,
them.
okay. I see.
Yeah.
That makes sense.
Do you know what proportion of the documents were marked privileged?
All of them, as I said earlier.
Every document on that hard drive that they took?
Yes, as I said earlier,
Okay.
the general counsel of my business marked all of them as privileged.
Sorry that we're repeating questions about things that you've already said. As lawyers, we need to make sure that we get all of the details correct, and part of that is repeating that back to you and making sure that we've understood it correctly.
Sure.
Yeah. It's not that we're not listening, it's just we need to make sure.
Sure.
Yeah, so thank you for clarifying that for me. If you choose to engage us as lawyers, that would be highly relevant, determining which of those documents are privileged and which would the ones that wouldn't be privileged, you would be obligated to turn those over to the ACCC.
Yeah.
And so that could be highly relevant to the issue at stake here.
Yeah. On the drive, I believe it was 13,000.
Okay.
10,000.
Oh, sorry. Yeah, 13,000.
Okay.
Okay.
Okay. What I might do is take you back to the cartel agreement that ACCC...
Alleged.
Alleged
Cartel.
A cartel agreement. Would you be able to go into a bit more detail about that?
Well, the alleged cartel agreement was, we had a board meeting about 6 months ago, and an arrangement called Project Casper had been discussed in that. It was only a draft proposal. The proposal was based on a customer report by the sales team to improve uptake of our well-known products in regional areas. So yeah, it was only a draft proposal in the board meeting that I was a part of. So yeah.
Okay. Could you tell us about XYZ's involvement in that board meeting, if there was any?
XYZ weren't a part of that board meeting, as I said, it was only a draft proposal. So I believe based on the customer data, the general manager, he said that the business could increase its regional market share by increasing the uptake of the product among regional users. I believe the rationale was to increase our slice of the pie, we must increase the size of the overall pie. To do this, the business would need to keep prices low, and so would the rest of our competitors, although they are seemingly very small competitors.
And what actions did the board look at to make sure that other competitors were going to keep the price low?
Well, I didn't do anything from there on. I was only in the board meeting when it was a draft.
Okay, and what did the draft say?
Well, it was exactly what I just said. So I believe the proposal was given the go-ahead afterwards. Yeah.
So there was no specific policies in this draft. It was more of an overarching, this is what our aim as our company is to do this and this and this. But it didn't say how you were going to do those actions.
Well, the general manager and a few other members, they did proceed with Project Casper. I was not a part of it. I am the CEO, but I wasn't a part of the meetings that occurred. I was a part of the original board meeting. Okay. They knew some managers from XYZ Group. They presented their idea after and then formed a Skype chat group. Again, I was not a part of this.
Okay.
Can I just clarify though that in your role as CEO, you were overseeing these matters generally?
What are you trying to say, that I did this myself?
No, I'm just trying to ascertain the relationship perhaps between you and the general manager. Does the general manager report to you?
Yes, but as I said, I didn't. I was only a part of the board meeting. So they had this Skype chat group. XYZ, I believe, was a part of it. And yeah, they shared pricing information.
Okay.
And yeah.
Do you be able to give us a bit more detail about how they shared pricing information?
Yeah, so they shared just our pricing information, and they agreed on a price figure for each quarter.
Okay.
Was there anything discussed relating to benefit to consumers resulting from those prices that you would discuss?
I wasn't part of the Skype group chat, so I did not know about Project Casper. I was a part of the original draft. I was part of the board meeting where the original proposal was, presented, and that's it.
Okay. Did you sign any documentation given to you by the general manager?
I did not.
Okay.
Okay. I know you weren't part of the implementation of Project Casper, but did you now, currently, not at the time, know some more information about it that would just help us understand the extent that ACCC, what their case that they likely have against the company is?
I'm not, withholding anything from you.
Yeah, sorry, that's not what I'm alleging. I just want to remind you that it is confidential, and the more information that we get from you, the more that we're able to help.
Well, no, I didn't have any other information. As I said, I didn't know about Project Casper. That's why I'm very stressed. I don't want to go to jail. It's very, very nerve-wracking. It's a very nerve-wracking time for me.
Okay.
That's very understandable, and there's a lot of pressure on your shoulders, I can imagine, and worry about the company.
Yeah.
Right. Do you have any documentation that was given to you by the ACCC alleging any allegations at all, anything that they are claiming?
No, there was just the Section 155 notice.
Okay.
Yeah.
Okay.
So you don't know anything further about the potential extent of the company's liability at this point in time?
No.
Okay.
No. All I know is that we've had this notice produced. I just haven't been able to sleep about it. It's very stressful. The previous lawyers that we instructed at the time, they were absolutely useless. Honestly, I'm very much for digital. Everything needs to be digital. In this day and age, and they use so much paper. Don't you agree that's absolutely terrible? I mean, in this day and age, that is just shocking. Wouldn't you agree?
I mean, it's probably good to have multiple copies of things for the purpose of the business. We're very happy to communicate with you digitally and online.
Sure.
And definitely that hard drive being digital is more convenient.
Yeah, the last lawyers were just terrible.
I might ask a few more questions about your previous lawyers, just to make sure that there's no conflict of interest or anything we need to be aware of there. So when did you take them on as lawyers?
So initially our General Counsel instructed Forrest Chattel solicitors. And that was just in the panic at 9 a.m. in the morning.
Okay.
They were just the first to spring to our mind, but of course very displeased with their handling of the dawn raid. So that's why I've now come to you, our trusted solicitors. Okay, we're very familiar with you. So.
Okay.
Sorry. Could I just ask, so could I get potentially an idea of the time frame here? So how long ago was the dawn raid?
Sorry, my memory, just so busy being, being a CEO, my memory is just not exactly amazing. So I believe it was about 1 week ago. Yeah, from my memory. Yeah.
Okay. And you went to Forrest Chattel solicitors immediately after
that morning.
When did you inform them that you would not be requiring their services?
Well, at the end of that business day, we had that consultation. They were terrible, shocking, not happy with them. So I've now come to you a week later. We've had a week to, like I said, I haven't been able to sleep. It's just, really very making me very nervous. I don't want to go to jail.
Okay, we can try to reassure those fears to the extent that we can. Just to clarify further, so in that space of 1 week, you've had no communication with any other legal representatives?
Correct.
And you have not been contacted by the ACCC in that week?
Correct.
Okay, great.
Yeah.
We're on the same page.
Yeah, I'm just by another lawyer's work, and I was anxious to make sure that we were able to engage with her and get the best outcome for her.
Yes, I think you're right that it was definitely reciprocal, where she was also trying to make sure, first of all, we were trying to establish what her issue was and what problems she needed help with. She was also equally trying to establish whether we would be a good fit for her. She talked about the fact that her company does everything online. She also talked about how quickly we could get work done for her. And I feel that our responses to those questions were reassuring and positive, and I think that she was very interested in engaging us further.
Yeah, I agree. I think she came in here wanting an answer that we were unable to give, and I think we did well at not promising anything. We explained the difference between criminal and civil liability, but didn't say that she definitely wasn't going to be criminally liable because she wasn't giving us any of that information. I think once we have those documents given to us, we'll be able to have a better understanding.
I think that my gut instinct was that she probably wouldn't face any jail time, given the fact that it was only 6 months ago that the project was started and she wasn't even able to confirm whether it was ever implemented. But I did not want to say that to her face, given that we had no information to confirm that, and we will have to, look over the documents that the ACCC took, and look at the way that the company was operating in the last 6 months in order to determine those issues.
Yeah, and I think in saying that, we are also aware that the intent to press fix is enough for prosecution by the ACCC, but it tends to fall on the civil side. So even if it wasn't implemented, the fact that they talked about it and wanted to do it,
there will be liability. Hopefully we will be able to, in the course of preparing these documents for her, we'll be able to give her more of that reassurance to say that it will probably be a fine that the company will pay.
Yeah, but until we see those documents, I wasn't comfortable saying that, communicating that to the client.
Neither was I. And I think we both flagged that to ourselves. How did you feel that she felt about the options that we gave her?
I think if we'd said those at the beginning of the interview, she'd be extremely grumpy, because that's not what she came in here for. But because we built a trusting relationship with her, and I think we'd asserted our authority and she trusted us, we were able to offer some outcomes about mitigating loss and mitigating jail time, rather than simply fully writing off that they'll be responsible.
I think that we were quite clear with that as well. And I feel that essentially in addressing the anxiousness that she was feeling, I think both of us tried to finish the interview in a way that would lessen that for her, and we were able to say that the first step that she needs to take is to sort out which documents are privileged and which are not. And we were clear about why that needed to happen, and we were clear about the fact that we could make that happen for her, and that we will get in touch with her soon.
Yeah. I know that for me there was a red flag as soon as she said 13,000 documents were privileged. I was just straight off that I don't think there'd be very, very limited circumstances when that would happen, so we need to look into that. I didn't feel comfortable promising her that we'd get our lawyers to work overnight. It's not how business operates, and I think I was clear about that.
And I think definitely that goes to the client and her expectations, and the fact that she came in here wanting this issue sorted out essentially overnight, and we, I think, gently lessened those expectations and gave her solid reasons as to why that is the case, and she seemed happy with that result.
I particularly liked how at times you came in quite strong and a bit more hard-lined. I think she needed to hear those things and have issues clarified, and then I was able to come in and re-establish that we were here to help her and re-establish why we were asking those questions, so that she still had a trusting relationship, but also that she, knew that we knew our stuff and could trust us with her legal, to take her on as legal representation.
Yes, I agree. I think we got that balance right. Do you have anything to add at this point?
Not at this point, no.
Okay, so great.
Yeah.
So I think we will go forward. We'll wait for instruction from her. It sounded to me that will probably happen.
Yeah.
That she was very keen to get someone on this immediately, and she mentioned that she trusted us from previous dealings. We should have a look over those documents as soon as she's ready to instruct us.
Yeah.
So I think get moving on this fairly quickly.
Yeah, I agree. I think we might need to just double check with that other law firm and make sure that all things are settled there and there's not any ongoing relationship that would, cause any issues for us. I think Steph was pleased that we really went over the issues, because it did sound like we'd misunderstood a couple of things, and we were able to clarify that because we went back and asked her for clarification.
Yes, I agree. Okay, great. I don't have anything further to add.
Neither do I.
Okay, we're done. Do you guys have any questions for us? Or?
Okay, so well done. Give them a clap. It does mark the formal end in many ways, so congratulations on getting to the grand final, and again, very polished, articulate. The listening, the attention you showed to the client was clear to us, facing in this direction, that the audience might have appreciated to the same extent, but very intense attention on what the client was saying and doing and responding, showing your listening and so on. I particularly value and appreciate the respect you show the client and their autonomy, because that's so big in being a lawyer. That the client is free to choose whether to retain you, someone else, whether to do this option or that option. Respecting that autonomy is big. You're not there to tell them what to do. So that came through very clearly too. I'll just go back through my notes a little bit. Yes, I've made the point on other occasions. There's usually an opportunity to make more small talk, and it turned out that the client was anxious and underslept and so on. So, small talk can perhaps bring that out earlier. Not a big point, but just be conscious that it can get a bit too habitual, where it's real small talk. It's really curious, who is this person and what state are they in? And, and you can learn that from the start, and that can really get through it more quickly if you can pick that up. Really good questioning on the raid, and you didn't let go until you got a good level of detail about it. And especially the way you framed your questions, like I've got a note here, why do they suspect cartel conduct? What was it that they said? Now, that would feed straight into a witness statement. What was said in the course of the raid by the ACCC officers. So that level of concrete detail is so much more useful than vague generalities. So well done on that score. And eventually, I think right at the death we came up, was the raid legal? I love that, because I was sitting in my notes there, the ABC raiding, being raided by the AFP, and it's not unheard of that a warrant is defective, and that has implications for the whole dynamic and the power relations and so on. So to see that as an issue, and the questioning was sort of going in that direction a little bit too. Again, I think these facts, and I've made this point before too, who exactly is the client in this situation? We've got a person, and we've got a company, and board and a CEO, and we've got criminal civil liability for companies and CEOs and directors, and it can get messy. And is this person here talking with the authority of the company to instruct you, or are they there as a CEO saying, I'm an officer? The company might want to cooperate with the ACCC, and as the CEO might not because of the criminal. So really to nail down consciously when you've got a director situation and potential conflicts, just be alert to that and making a clear note of your client and the latter situation. Just a couple more brief things I think I might have here. So a couple of things when it came to advising the client. There was one thing that was sort of a bit of a red flag for me, and I know it was qualified before it was said, but it sounds like it was price fixing. Now, to me, that's an alarming thing to say. Qualified, good, the qualification's good, but based on the information you have, just to couch it as a risk, rather than it sounds like, because the client can walk out the door saying, oh, they said it sounds like price fixing and tell the whole world, but that's really dangerous. So just be careful and make sure the qualification is emphasised if you're saying that couched on, based on what you've just said. But, and then we very quickly, a minute later, moved on to the alleged price fixing, and there was also a reference, I think in terms of giving advice, you should cooperate with the ACCC. Now, and this goes back to my earlier point, who should? The company or the director? What about the right to silence if this is criminal? Maybe it's not in the client's interest to cooperate at all. Where is the onus of proof? And if the onus of proof is on the ACCC or the AFP, maybe the best advice is sit back and see what they do. Because the larger structure of this situation is, what's the next thing that might happen in the big picture? Well, it's either a writ or a charge coming from someone else in your direction. So really, you're in a defensive posture, so you have to put on your shield mentality. So, and there may be benefits to cooperating. Indeed, you might get special treatment or so on, but that has to be thought through a little bit before you jump. Cooperation is a good thing. Well, crime, right to silence, maybe make them prove it beyond reasonable doubt. Just sort of be careful. It's not always the right thing to do. And the onus of proof thing starts to become important, okay, in this situation. I think that's all of my comments, and I've probably taken far too long, so I'll hand over to Catherine.
I agree with all of that, so I'm not going to repeat any of it, but picking up on the delineation between who your client is, again, mentioned conflict of interest as part of the retainer, so that's something that you need to think about. The client mentioned several times, we've used you before, who's we, her, business, etc. But then there were times where whether to allay the concerns of the client or whether it was in the back of your mind but not fully articulated, you did sort of specify who your was in terms of, is she personally the you are referring to, or was it the business? So it was, the awareness was there, but maybe not as spelled out as you would want in a real life situation. I thought you oscillated well between using we and I. Clients like we because it presents you as a unified front, but then when you thought you might be going out on a limb a little bit and didn't want to include, your team member in your I think she might agree, but I think so. That was an appropriate switch, which I thought was done really well. I thought you read the client very well. You didn't shy away from giving difficult advice, being, managing that expectation that this may not actually come out the way you want it to, but we'll try to minimise the harm. So that's important, and you can fall into the trap at the initial consultation of people wanting work and wanting to build that relationship and then setting it up almost for disaster from the beginning. So that's not something you did at all, and it was handled really, really well. I thought you closed out very well with the other law firm and raising with the client whether or not that retainer had in fact been terminated before you went all guns blazing, and there were 3 of you in the picture, the GC, the previous firm and yourselves, so that was addressed well. You really honed in on privilege, and obviously it's something that you've foreshadowed with the client, you've mentioned again, so all of those sort of big ticket items that could land you in hot water alongside the client were ticked off really nicely, and I think the client was very grateful at the end for all of the summarising and just the human element, like the understanding that it was stressful. That can really be missed by people who go, this is everything I need to tell you, and then, oh, our time is up. So I think you did all of that really well. Thank you.
I agree with both Craig and Catherine. Your debrief was insightful, and you really honed in on the things that perhaps you could have done differently or better, keeping in mind, I always think in these, keep in mind that you only have 30 minutes and it is time, and if you go over time it's pretty crucial insofar as that is concerned. You manage the expectations well, and as Catherine said, you were not shy about saying, I don't think you're going to, in your head you're saying, I don't think she's going to like what I'm about to say, but I'm going to say it because I have to. So it was really good to see you not shy away from that. And I think, and with your, one of the other things is, on Craig's point about who's your client, sometimes getting them to draw a diagram of the company structure can be helpful, because it helps you visualise what it, they've got 3 offices, you've got 1 company, but the 3 offices could be subsidiaries, who were the directors. So sometimes just getting them to draw that, sketch out little diagram can give you the ability to then try and say, okay, who are you here representing? Because you could have had many hats. And potentially if she was just there for herself as an individual and a CEO, your advice might have been a bit different to that of the company. But overall, well done.
Thank you very much. Thank you guys.
Yeah, I think another
on behalf of ALSA, I'd just like to thank our judges for taking the time to judicially participate in this wonderful client interview.
Thank you.
Appreciate it.
I love the sound of it. Thank you.
Thank you.
How exciting.